days, 5 days. The court gave them from yesterday to Wednesday morning to serve us. And from Wednesday morning, we have from Wednesday morning to Friday, Monday morning to serve them. We are coming back to court on Thursday to argue the appeal. So because what they wanted to achieve is when we're in court, they say, well, make sure they come and we have an application to amend our grounds of appeal and also amend our extension of time for us to come in. And court to say that they don't think or don't have the luxury of time to allow parties to be coming every day. No. So they will now court will say, okay, we don't have a day this year. You can come back on January. But that doesn't work out for them. Then now we're going back to court on Thursday, 11th of May, 2023, to argue the appeal on the merit. Now, let me just clarify further. What has been making the headline in Nigerian media is that federal government filed additional grants, 9 grants of appeal against the leader of the people of Biafra. These are applications in substance that's frivolous, means nothing to us. Why? Because what they are actually asking the court to elongate, the grounds they are standing, is already contained in their in their 5 grounds of appeal, 5 which you challenge. It's contained there. These facts are contained in the original grounds of appeal, the 5. They are the essence of what I do. What they want to achieve. This is to delay the proceeding, nothing more. Just to lift one sentence and say it's the grant of appeal, lift another sentence, the grant of appeal. So they will stand just like what happened in 2021 when Nnamdi Kanu was abducted in Kenya and brought to Nigeria. From 5 count charge, they expanded it to 7 count charge. From there to 10, from 10 to 15, and it's all over Nigerian media. But the federal government has 5 amended 15 count charge against Nnamdi Kanu. We want to escape this one. So the essence of it is to cause media hype. So people will think they are doing something useful or that they are serious about the matter. They're not serious about the matter. At the end of it, they will challenge the charge, and it was struck out. We're going to go to court of appeal, and the very same was also thrown away. So that will tell you they have nothing before the court against it. So it's not for us to make this clarification. So people think that there's anything there's anything serious about what they're saying. There's nothing serious about what they're saying. What they're telling what they want to amend is already before the court. We have it without us. They've argued this point in their original appellate brief they filed last year. We have it. We've argued it. I've responded to them. So they're merely expanding it so that people will now say, oh, they have 100 grounds of appeal against Nnamdi Kanu, and that probably will not come out on this one. This one is more, Nigerian mentality, and probably from misinformed elements who are following, who are being misled by their wrongs and misleading information. So it's more for us to clarify and tell our people that there's nothing, there's no problem. There's nothing to worry about. We're in perfect control, and also God is in control. So what they are trying to do in court, we are separate of them. We have already taken care of that. So let them come to court. Thank God that they have been now given time. They can't escape it. They are coming to court on the 11th. Let us go there and appeal on the merit. Simple. So thank you. If they ask me further questions, I maybe have to give you further explanation. Thank you so much. Or if you don't, if there's any area it's not clear, I didn't make it clear to people to understand, I can also clarify because I'm talking to our people.
There were MAZI, Barr Ifeanyi Ejiofor, for your clarifications and briefing. One thing you talked about this another, is it 11 ground or count ground for counts, other counts, 11 counts, and you have clarified it that it is not something new. What they are trying to do is media hyping, so that our leader will be condemned by the public. It's just like media trial now. But you've clarified it because that is what is going on the social media right now. That MAZI Nnamdi Kanu, but thank God that you've clarified it. But now there is something that I want to ask also. You made mention of appeal or by the prosecution, and sometimes they don't inform you, the defending lawyers. They don't serve you any paper. What is that? What are the legalities concerning this? Is it legal for maybe the prosecution to do something, file a charge or another application, whereas they don't inform the defending lawyers. Is it legal under the Nigerian law or Nigerian constitution, please?
Thank you so much, Mr. Jonathan. Let me just take it calm so people understand. First of all, let me correct you. Use the word expression count on the charge. There's no new count charge. There's no new charge against MAK, against Nnamdi Kanu before the court. What the amending is their grounds of appeal, which is just like somebody who is challenging the decision of the court. He's telling the court, the upper court or higher court, and challenging this decision on ground X, Y, Z, probably error in law and facts. And those grounds are just maybe issues of law and issues of fact, these are facts. So it's not charge, it's not count. So I have given you a clear detail here. You know, see, what happened in court yesterday, what the legislature was trying to explain to the court yesterday. From the day one of this case, starting from the lower court, before the federal high court, before the Sindaco's court, federal government has not been forthcoming. They have not been diligent in the prosecution of this case. What they wanted to achieve at every given point in time is for them to keep Nnamdi Kanu in detention. That's all. Now I'll explain. When we are in federal high court, it has happened up to 5 good times. They will amend the charge. A matter will be done for hearing or trial. Then, obviously, in view of the fact, in view of the frivolous nature of the charge and post-screening nature of the charge, we usually challenge them. Then a date will be fixed for hearing of the charge application, challenging the charge. A day before that day, they will, most times in the night, around 5, 6 o'clock, they will serve us amended charge. And as soon as they serve us those amended charge, they will make it available to the media before they come tomorrow. So by the time before I wake up in the morning, it's already being reported in the media. Paragraph has them five additional 7-count charge against Nnamdi Kanu. So it will not send fears to people. Are you with me? So it will send fears to people that look, hey, Nnamdi Kanu go face something 10-count charge, 17-count charge. So it has been the practice. Or when we file an application, like when we file an application challenging the competence of this part, they will not respond. They will not respond most times. They will respond the day before the schedule for the hearing of the application. They will file their counter. And the essence of doing that is to truncate the proceedings of the court on the day schedule for the hearing. Truncating the proceedings of the court means to stultify, and that's to stop the matter from going on. Because when you serve us with a response, a response to application we file to get a process strike out, we are entitled to respond to that application, to that response by way of reply. Now, and it's the law. We have to reply, because if we don't reply, then that means we are waiving our right to reply. And it will assume that new issues you raise in the application, your response, has been considered by us, have been waived by us, and admitted by us. So we are under an obligation to react by way of reply to your response application. So they usually send us this stuff a day before the schedule for the hearing. And that was also called ambush. It has been their style. I give you an example now. Tell me what will cost a federal government, what will be responsible for a lawyer. A lawyer in a federal government, in a federal office, to file a process before the Supreme Court on the 5th day of December 2022. You file a process as important as responded brief for the Supreme Court. And not even stop at that. You enter into an undertaking. You know what I mean by undertaking? Written undertaking before the decision of the court. That I hereby undertake to serve this process on the respondent counsel. You know, if you don't sign that undertaking, they won't give you those process. So you have to enter as a lawyer, and you are signed as a lawyer because they can't give those process a non-lawyer to sign, to enter on the thing to sign. No, you must be allowed to enter into undertaking before the decision of the Supreme Court, before they allow you to go and serve a process. Now you file a process on the 5th of December. Very important process as appellate brief, which you are challenging, upon which you have already filed application to get the appeal dismissed. You file this process on the 5th of December, and you read it from us. After into undertaking before they reach the Supreme Court to serve us. They didn't serve us. Till yesterday, they've not served that process.
MAZI, before you continue, let me put it here as a question. Is there any legal backing for this type of ambush? Is there no law maintaining that there should be a frame of time instead of waiting for maybe less than 24 hours and to start doing all this?
This was exactly what I discussed with some we discussed yesterday. There's a law regulating this proceeding. We call it fast track rules 2013 or Supreme Court fast track rules 2013. It's the right time. We didn't wish to, because this appeal is so that can be heard speedily. It's appeal classified under this rule that are among the appeal that can be heard day to day by the court, day to day by the court. So, and there's a time we didn't wish to file this first point, this application, the processes being conducted, being had under this proceeding. You are allowed to file this appellate brief. Later, 10 days after you compile records and serve on the parties. They didn't file. Now, it's been going without consequences. Ordinarily, if you ask for cost, like yesterday, we told the Supreme Court this matter has been in Supreme Court since October. They were shocked. It was said in open court by Lensel that this appeal has been in this court since October. And they know the nature of the appeal. And they were concerned about the delay. And when it has to do with liberty of a citizen, and when it has to do with the direct health condition of Nnamdi Kanu. So these are things they consider, because it's also by now, should have been had by now. So, and portion to which they give us this short date, 2 weeks from yesterday, to come back and argue the appeal. We understand that, when you are battling with the system, it's an establishment we're fighting against. It's the government of the state. So that's why they do whatever they want. If the government is not involved, I don't believe that a lawyer, an independent matter can be conducted in that manner. You will come to a Supreme Court, and file the application and enter into an undertaking to serve same on the parties, and went away with it without serving us the processes. Then you can come to that court, back to that court to talk to the court. It's act of misconduct, professional misconduct on the part of the lawyer. It's just act of misconduct for a lawyer to ambush another. It's an act of misconduct. So, however, because these are traps. What I want to tell the friends this time, that these are traps they set for us, and traps to ensure that there is a delay in this case. And when you understand this trap, you have to be careful and circumspect. Circumspect is saying that you have to align yourself with a position that will allow the appeal to go on quickly. But if you want to challenge every of the irregular steps they're taking so far, since this appeal was filed today, that means this appeal may not even be had this year, and who is suffering is a client. So we have to align ourselves, our position with a process that will allow the appeal to go on speedily. So that, not without mentioning this irregularity before the court yesterday, it was clearly marshaled out by the NSF as to how they transmit record and serve on the parties of 2nd of November 2022, and they didn't file processes appellate within time. They file and hit from us. Now they file a book and amend their grant of appeal. They file it since February 16th, 16th February 2023. They didn't serve us on the 2nd of March. So what they are trying to do is just strategies to buy time. So this man will be there. They want to keep him there. And when this appeal is not had, it's not going anywhere. So, but luckily, God intervened yesterday. It was a very, very wonderful outing, because God saw with us that, look, there is actually a plan to delay this proceeding. They are doing it because they know that Supreme Court has no luxury of time to entertain cases, because the docket is full. So, but after explaining to the court about the nature of the case, of course, it's statutory, and the conduct of the prosecution in this case, of the appellate in this case, the court has to give us a shadow to hear the matter. Even the cross appeal I mentioned here, we cross appeal on some issues of law, which that has to do with the show of appeal. And they didn't respond till also late this year. They responded. They will file our response, our reply immediately. So that one has been settled. It was also mentioned to the Supreme Court yesterday that our cross appeal has been settled, because we filed the responded and we file our appeal, our reply. So it's adjourned till 11th of May. Once this main appeal is had, we can cover appeal can be taken together, because they have the same appeal number. So now that it's not penalty, that's penalty. Most cases, court will sanction you. Court will ask you to pay tax, to pay fine, right? And in some cases, you will be referred to NDA. So there are penalty and consequences for this kind of actions. But you know, when you are doing a case against establishment, which obviously have control over all other sectors, so you have to be up and in. You must be circumspect. You must be careful and know when to act and when not to act, and know when to certain step or decision to take at any given time. Thank you.
Well, the woman say Barr Ifeanyi Ejiofor. And before I dive into another aspect, I want you to please clarify again. The court judgment, appeal court judgment received on the 13th day of October 2022, discharging our leader, that he should not only that he should not stand any trial in any Nigerian court. Okay. Yes. Today the case is being taken up, applications on Supreme Court, which is the apex court in Nigeria, normally. Now, what I want to ask is this. Is there any law compelling that appeal court judgment should be respected first before any other Supreme Court or any other appeal or any other case? Is there or is it constitutional? It doesn't matter that it is against the establishment, but the establishment normally in a democracy, in a republic, the establishment must go through the rule of law. That is it. That is how it is all over the world. But what I'm asking is the Constitution. Does the Constitution allow somebody discharged by the appeal court, no matter the Supreme Court application or charges or anything again? Does the Constitution allow the person to continue being detained, or according to we talk to Biafrans, talk to the whole world according to the Nigerian Constitution, not according to how the establishments wants to do their thing? No. Is there does the Constitution mandate that court ruling should be obeyed first, or is there any way the Constitution allows the defendant to still be held pending the outcome of the Supreme Court issue? Please clarify that, please.
Let me just explain this to you. When I was doing the introductory part of this discussion, I expressed concerns about the fact that there are what are obtainable in the criminal jurisprudence and what are not applicable to jurisprudence. And most times, what's obtainable in civil jurisprudence is not applicable to criminal jurisprudence. As a matter of fact, what I'm talking about is an appeal. It's a criminal matter, criminal appeal. The judgment of the court of appeal delivered on 13th of October 2022 is very clear in terms and unequivocal. And the law is that you must obey this judgment of the court of appeal and consequential other mediating. And there's no even under the party's direction of court of appeal, or court of appeal party's direction, or under the court of criminal appeal under the court of appeals, does not allow for stay of execution of criminal appeal of criminal judgment on criminal matters. Doesn't allow it. Now, these are issues we can pass before the court of appeal. But now let me just explain this. Confidently or procedurally, a party have the right to challenge the decision made by lower court before the upper court, higher court, by way of appealing against that decision, and by extension applying for stay of execution. It's allowed under the civil appeal. Our contention is that this kind of decision is not allowed, but there's no rules to amend provision for it under the civil appeal, under the criminal appeal. All the contended before the court of appeal. So ordinarily, there's no rule that allow you to stay liberty of a citizen. It's not hard, and it is more so that all the all the judgment of the court or the law or the Supreme Court they relied upon, moving the Court of Appeal to state education are all civil cases. They are criminal matters. All the judgment they started before the Court of Appeal in granting that an application for stay are all civil cases, they are not criminal matters. So you see, these are irregularities we challenge in our motion to dispute the appeal, to dispute the other state education on our appeal. So there is no. So I don't want to go delve much into the merits, into the substance of this issue, because of course it's matter before the Court of Appeal and Supreme Court. And as I speak now, of course everybody, including the DSS, the police, the military, the civil defense, the man of war, the public, everybody's listening to me as I speak to you, even the courts. So there are issues I may not delve into, but I have to kind of make a highlight as to what I want to understand. The fact that these are not done, it's not allowed under the law. I will have a final appeal against what they did in Court of Appeal by staying in the execution of judgment of Court of Appeal. That's the only option available to us. We can't fight them. And the appeal is before the Supreme Court. Now, the own appeal is now for hearing. And yesterday, the court made reference to the appeal. I said the appeal also will go along with the appeal, which is going to be held on the 11th of May. So let me don't go deep into, because argument I'm going to prefer this evening will be part of argument that will be canvassed in court on the 11th of May. In moving the court to, first of all, displace the other, and also allow our second appeal on that. And also in moving the court to dispute their own appeal. So I wouldn't want to canvass it extensively in this program because of the fact that all of them are listening to me. Because once you mention Ejiofor is coming to address the media, they will start talking about Ejiofor. They will now start talking about they have to suspend everything they have to listen to me. It happened yesterday when I was giving an award somewhere. I was giving a speech, and some people say I will not. Some people protested against it. At the end of that, deliver the speech. So let me not go into that. So the point is that let me not go into for May 11th, 2023. But I can assure their fans that God is on the throne, and God being so kind, God being with us, we are going to appeal. We are going to get this appeal dismissed. God be on our side, because Nnamdi Kanu has not committed no offense on the law and has been discharged by court, by order and judgment of court, superior court. So we are doing everything humanly possible within the limits of law and within the confines of law to give him the best representation. Thankfully, we have an erudite senior advocate of Nigeria, almost nobody who is leading us in this case. So they be assured that God we perform wonders in Supreme Court. God be so kind. Thank you so much.
Well, finally, before you go, I want you to talk about the health of MAZI Nnamdi Kanu, who is your client and our Onyendu, our leader, the leader of the indigenous people of Biafra. We have heard many things, about tuberculosis outbreak in the where he's been illegally detained. Please start by telling us, when last did you see him, and how is all this his health? Please, people are listening. Please go on.
I was with him yesterday after the proceeding before the court. We spent some time together, and he was recently diagnosed of tinnitus, the ear issue. So I know the DSS medical department does not have the advanced medical equipment to address it. It's still on medication. And heartburn, of course, I've made it to the point that we having heartburn. And also depletion in potassium content. So these are issues he's having. But he still is strong in spirit. I'm saying strong in spirit that there must be light at the end of the day, at the end of the tunnel. So, but he's not good health-wise. I've been saying it time without number because I own the word explanation and a duty, an obligation to tell them whatever my findings will be each time I visit him. So, and I don't come to the media to regret. I don't come to the world to tell the world what's not the truth. So I will tell you when it's better and when it's not better. But yesterday, I was with him to brief on what happened in court. So we had an extensive discussion on the matter before the court and what was we're expecting to happen on May 11th. It's on our level of preparedness too. So, and what we're expecting to do by next week when they start us the relevant processes. So, and also we discussed about his health too. So he said he's still on medication about the kind of those to undergo surgery. So these are the complaint he led to me yesterday. So, and I better also that I made it known to the world by this platform. So that's all. So that we're storing strong in spirit tenaciously, and we're believing God that the God will do His will, and we're praying for him. He'll be alive. He will come out there alive and strong. So God is with us. God is with them. Thank you.
There were. Thank you very much, Barrister Ejiofor, for this update. I don't know whether you have anything. You still have anything to say as your parting shot on this program? You know, because many people are really worried about our leaders' health. You know, so please go on if you have anything to say.
The only thing I can tell your fans is to be strong, remain focused. They should not be distracted because a lot are going on. Of course, what I want to also repeat at this point in time is that many people, when you see this kind of thing going on, you see a lot of people who are working against the interests of Nnamdi Kanu, either by actions or by deeds or by conduct. So, but let them remain focused and also obey the instruction from the central body. So that's where I can tell them, possibly not to be distracted because a lot are going on. Of course, you can know. I want to appreciate that we have changed our strategy. It's something that informed it because I discovered that there's a lot of things are not working properly the way it's supposed to work. And once you're able to identify your enemies, you have to treat them as such and place them where they belong and make sure that you work hard and progress. So what I'm telling our people is to remain focused, be prayerful, be abide. These are things you usually tell me. Remain be peaceful in their conduct. That at the end of the day, the truth will prevail and we'll be freed. And God will make it happen sooner than expected. Thank you so much, and God bless you all.
The War Barrister Ejiofor, thank you very much, our erudite lead counsel. We understand that you are at the front line, bearing the brunt of everything. But we must continue.
Thank you so much, and God bless.
The War, thank you very much. So much. I think this is where I'm going to leave you. Thank you. Thank you. This is where I'm going to leave you.
Thank you, Mr. Jonathan. God bless you. God bless everybody. I appreciate you. Thank you for having me in your program.
Thank you.
God bless. God bless, dear friend.
There were. And you too. Thank you very much.
Thank you so much.
There were.
Bye-bye, my brother.
Thank you. This is where I'm going to let go. Dear friends, you have listened. So every other thing we continue pushing on because this is a process. Thank you for listening. From me, Mars Jonathan from here, it is simply good evening.